So in Georgia, how is bond determined when you're charged with a crime? In the state of Georgia, if you're charged with a misdemeanor, by law, you should have a bond set. Now, there's different variables that take place in that. If you have another case and you're out on bond already, well then that bond can be revoked. If you're on probation, they can place a hold on you to prevent you from bonding out. But generally speaking, if you're charged with a misdemeanor, such as like DUI or battery, something where a sentence can be no more than 12 months, then by law you should have a bond set. For felonies, cases that can carry a prison term, so something beyond 12 months, so something starting at 1 year all the way to life. So think murder, aggravated assault, aggravated battery, those kind of things. Then it's not necessarily set in place beforehand. So there's not an automatic right to bond on a felony case. So if that's the case, then the courts look at certain factors. There's a case, it's called Ayala, A-Y-A-L-A, v. State. And that case set out the factors that a court looks at on whether or not they determine bond. And there was 5 factors. And basically what it comes down to is there a substantial likelihood of you committing a felony while you're out on bond, pending the trial in this case? Is there a substantial likelihood that you won't appear in court? Is there a substantial likelihood that you'll intimidate witnesses, that you're a threat to community, those kind of factors. So what an attorney will do is request a bond hearing and bring you before the court and argue those 5 factors, these factors. And what we argue is ties to the community. All right, we want to show that you are going to come to court. And we do that by showing that you have family in the area, that you've lived in the area long, for many years if you have, that you have a job, that you have all these different variables to show that you're going to be in this community, you're going to come to court, because you're not gonna flee because your family lives here. You're not gonna flee because you need to work and you have a job lined up. Then we're going to look at your criminal history. We're going to show hopefully that you have no history and that there's no likelihood, no substantial likelihood that you're going to commit another felony while you're out on bond, okay, or be accused of committing a felony while you're out on bond. We can argue, hey, this guy's 40 years old, 30 years old, he's got no criminal history, so that in and of itself speaks for itself. That shows that there's no substantial likelihood of committing a felony while he's out on bond. Therefore, we should grant him a bond, right? So criminal history is a big factor. Then, depending on the case, what the allegations are, we can argue different things in mitigation as far as there not being a substantial likelihood or risk that you're going to intimidate a witness or threaten a witness or anything like that. So depending on the charge, depending on the nature of the charge and your criminal history, we can argue for ankle monitor to ensure that, hey, we're not going to go around this place, we're not going to go around this victim, and that's tracked, that's monitored by the court, so it gives them an assurance that you're not going to interfere with anything, right? So we can argue for ankle monitor or house arrest or curfew, any of those kind of restrictions, to ensure the court that we're not going to bother the victim, those kind of things. So we're arguing ties to the community, we're arguing lack of criminal history, but we're also arguing we're not going to harm the victim, we're not going to contact the victim, the alleged victim, anything like that. So the court looks at all those factors and then we'll make a determination on bond. And bond can be set. We have to argue for a reasonable bond. That's what you should be entitled to, right? And so reasonableness is determined by the court, really, unfortunately. Hopefully they will look at the charge itself, but then your likelihood to make that bond, that's the biggest factor. Are you likely to make that bond? So for instance, if it's a felony and you have a public defender and they set a $200,000 bond, well, is there a likelihood that you're going to make that bond? Well, I don't know. Usually not, right? And so the courts have determined if it's a unreasonably high bond, well, then it's basically like having no bond at all, right? And so if a court does that, well, then an attorney will file a motion to reconsider or modify the bond to lower it. But we want to argue for something that's reasonable and something that you can make. And so the court will determine all those things by looking at those factors, looking at the charges, and looking at the substantial likelihood that you'll be able to make that bond. Another thing to consider when looking about bond and felonies, the state of Georgia says if you're in jail and you're held without bond, then you must be indicted within 90 days. An indictment is where the district attorney presents their case to the grand jury, and the grand jury determines whether or not they're going to move forward with the case. So that has to be done within 90 days. You have to be indicted if you're held in jail without bond. If that's not done, well, then the state of Georgia has determined that then by law you're automatically guaranteed a bond. All right, so you get arrested and you're held for 90 days, and the state has not moved forward with your case, they haven't indicted it or formally accused it, then the state of Georgia says by law you're entitled to a bond. Now, you will still have to file a bond petition and go before the court, generally, if the district attorney won't agree to it. But you have the strong argument that, Judge, we're entitled to a bond at this point. And if the court thought this was that serious, if the state thought this was that serious of a charge where they shouldn't have bond, then they would have indicted it. So 90 days is crucial if for someone who's in jail and there's not been an indictment. That's a big thing we look for. So sometimes, depending on the charge, if it's a very serious charge, we tell our clients, you might want to wait closer to that 90-day mark. That way we're entitled to a bond. We have to get a bond. But in most cases, 99% of the cases, once we're hired, we file a bond motion right then and there, and we ask for the next available court date, and we gear up to have a hearing where we look at those factors. We argue for a bond. Most of the time, we will argue on behalf of our clients without having to call any witnesses, but sometimes we want to call a witness to testify to these factors. So a family member who can testify, I live here, he lives with me, he's got a job, all those kind of things. We want to get all that on the record so a court can make a determination based on those factors and get our clients a bond. So to recap, misdemeanors, you're entitled to a bond as a matter of law. Felonies, some courts, some counties have it already determined if it's a certain felony and you don't have a history, then automatically they'll give you a bond. But sometimes you have to go forward for a bond hearing to have a court determine whether or not a bond is going to be set. And they look at factors, they look at criminal history, ties to the community, likelihood of getting in trouble while on bond, likelihood of intimidating witness, those kind of things. And the court will make a determination. We argue for a reasonable bond based on the charges and your likelihood of being able to afford that bond. And then if you're not indicted within 90 days and held without bond, then by law, the state has to agree to a bond, or the state has to determine a bond and set a bond.